Good morning, everyone. I think it's 10:35, so I'm going to get started. I'm not sure if there was some other rhythm to the way they were doing the breakout sessions earlier. My name is Tony Franco, and I'm presenting with my partner, Peter Ford.
Morning.
And we're going to be speaking about the recertification rules that we are regularly having to deal with for our clients that are involved in different transactions, particularly involving M&A deals and or contracts that are being novated. But because the recertification rules really go beyond just that, we're going to explain to all of you, what these recertification rules mean from all the nuts and bolts from the moment you submit a proposal to things that can trigger recertification that you need to be aware of because of the implications of recertification. There are certain housekeeping things that we need to make sure we've touched upon here for the audience. First of all, obviously, I guess there's an exit here, back here. It's an emergency where you guys got to go. Phones, I'm glad actually I heard that because I got to turn mine off myself. Sorry, you guys. And then we will, thanking our sponsors. Frankly, I don't know who our sponsors are, but thank you very much, whoever is sponsoring this event. But I will say that we sponsor a lot of events. So Polero Mazda does do a lot of these sponsorship of events for Sammy, a lot of other things. Just briefly to explain to you guys something about our firm and who we are. Peter and I work with a small firm called Polero Mazda out of Washington, D.C. We have 20 lawyers there and 2 out of Colorado. Peter actually runs a Colorado office. And we have been representing government contractors for over 30 years. And our bread and butter is representing small businesses. Many of which we've seen grow over all these years we've been practicing, and they've become mid-sized firms, large firms, and during the course of those years, we've been able to help them not only through many of these programs they've participated in. The 8A program is something we've been working, we've had clients we've represented for many years. Then as these other programs were created by Congress, such as a Hub Zone program, the Service Disabled Veteran-Owned Small Business program, the Women-Owned Small Business program, we were right there as soon as these legislation was being drafted, making sure we got our arms around what rules we're going to apply for those programs. Besides working with companies that participate in those programs, we also work with their teaming partners. Many of our clients are making sure that when they are going after these contracts that are set aside for small businesses or service disabled veteran-owned small businesses, et cetera, that they're doing things right because they need to be very careful that they're not affiliated. And so we have a significant depth and breadth in representing firms that are not in those programs that are trying to make sure they're just doing the government contracting right. And we do represent so many small businesses that are focused on just general government contracting issues that they need to come to us for assistance. So we're a general full-service firm. We represent clients in government contracting. We do their labor and employment. We do litigation. We do a lot of corporate work because a lot of our clients actually start their businesses for the purpose of growing and then selling. And that's why these recertification rules are so important, because we have noticed that the SBA has been making these rules stricter and stricter and making it more difficult for small business owners to be able to sell their companies because of the impact that the recertification rules have practically on on government contracts. And then the market out there looking for companies that are trying to acquire small businesses, but when they realize what the recertification rules trigger, they then step back and may not want to pay what they should be paying for these companies. So we have seen changes in the market because of the recertification rules. During the course of the presentation, please don't hesitate if you want to raise your hands. I know that oftentimes it can be done during the end of a presentation, but some of this information, it's highly regulatory. So we're going to try to keep you guys awake. But it's important because it is these regulations that are so critical and how you understand them as to whether you comply, because the impact of not complying with these regulations can actually result in civil and criminal penalties. And people sometimes don't realize the importance that the moment you submit an offer, you are certifying to certain things regarding your CM registration. So I applaud you guys for being here to want to learn about this, because a lot of folks out there just don't know these rules. And we actually help a lot of clients with protests, et cetera, when they realize that maybe their competitors are not keeping on top of what they need to be doing when they're engaging in certain transactions that trigger recertification. And Peter and I were going to go back and forth. I'm going to do a number of the slides for you, and then we'll go back and forth. And don't hesitate to, just like I said, ask any questions. The overview is we're going to explain when a firm needs to certify or recertify, and frankly, I'm sure most of you would know this instinctually if you've been doing government contracting. What are the triggering events that require recertification? That's where we're going to get into an area that's a little bit more complicated, because you have these SBA regulations, and then you have the FAR rules. And as you may know from a lot of other SBA regulations, sometimes until the FAR catches up with the SBA regs, many contractors don't feel that they have an obligation to do things unless it's in their contract. We're going to speak briefly about the recertification requirements for flow down to subcontractors. That's going to be a very quick slide, because frankly, when we proposed for this presentation, that was just one of the issues, and it's not really that significant an issue, because primes really have significant discretion how they do that. And then the impact of false certification, which I think, as I just mentioned, they can be very, very bad. When we're working with clients that are under investigation, one of the first things that we know that DOJ lawyers are looking at, the IG is looking at, is what did their SAM certification say? And some people don't realize that you need to, contractors don't realize that you need to be constantly updating them if certain triggering events occur under the regulations. Peter, if we can go to the first slide. With regard to the first thing, as you all know, offers must all be registered on SAM at the time an offer or quotation is submitted. And this is actually very critical for you to know if you are also thinking about creating joint ventures. A lot of our clients are pursuing contracts creating joint ventures, and you have to make sure that that joint venture already has its SAM registration. And unfortunately, we've seen many cases where SAM registration can take time because of glitches in the system. And it is a nightmare when a client comes to us, wants to put together a limited liability company to joint venture to pursue a contract. You're spending a lot of time putting together and negotiating the joint venture agreement, and then they want to create an LLC. Proposals are due perhaps in 2 weeks, and those are clients of ours that are really on their game, plan this way ahead of time, but some don't. They all of a sudden realize, oh, here's an opportunity to let your team. SAM, you have to be SAM registered. The moment you form this LLC, you got to get the DUNS number, et cetera. And simply by virtue of submitting an offer, you're basically verifying that whatever representations and certifications you've made in SAM are accurate and current and complete. So you need to realize that that's the way these solicitations are issued, with the expectation that you're saying that your SAM registration is accurate. And unless the acquisition is exempt under a FAR clause that, regarding recertification, you need to make sure that if you are submitting an offer at the time the offer is submitted, that you need to make sure that you've gone back and double checked to make sure that anything that has happened in the prior year has not changed, because you need to then immediately change your SAM registration to update it with whatever may have happened that's resulted in a change in what you have indicated. And this is obviously critical with regard to size, because that's what the SAM registration is really triggering for our purposes here. The importance of making sure that your size is accurate, given any events that occurred that could impact your size. Now, with regard to the verifications, these are the provisions that are in the FAR regarding the certification. And you verify your size, but you also are verifying whether you're a SDB, a veteran-owned small business, a service-disabled veteran-owned small business, a woman-owned small business, or one of these other entities. And so, to the extent that you're pursuing contracts under some of these other programs, it's also critical that you are actually eligible under these other programs, which is a reason why you're not looking just at size. If you are a service-disabled veteran-owned small business and you're certifying to being a service-disabled veteran-owned business, but in fact you may have owners and an operating agreement that makes you not eligible for the program, technically you are not submitting a false certification if that's not accurate. And so you have to also, if you, for example, are in the 8A program and you've done things that really make you ineligible for the program, the moment you are submitting offers and certifying that you're eligible for the program, if those are not accurate and you don't realize that what you've done actually makes you ineligible for the program, you've now exposed yourself to liability under those contracts. If you have a DOJ lawyer and IG investigator who's looking at why it is that you have indicated that you are eligible for this contract when in fact you're not. Peter? Thanks, Peter. Sure. When must a contract update the reps and certs? As you probably all know, if you're doing government contracting, under SAM, you have to do it once a year, And normally it's a year from the date you initially went ahead and made your SAM registration. And so we have clients that are regularly, telling us, oh, now I've got to register, it's June, it's July, and everyone is different. Keep in mind that when you are certifying size, you're certifying size for the prior 3 years. So you could be in a situation where you could be certifying in SAM in June, for example, of 2019, that you're small based upon the last 3-year average, even though now you're in a year that you know that you're going to be large. But what matters is your size the prior 3 years. That said, to the extent that there's anything you've done that makes you ineligible for a particular program, at the moment you're certifying, if it be 8A or Veteran Owned Small Business or WSB, what matters is at that point in time when you're doing the verification. Next slide. Now, with regard to,
yeah, this is me.
Is this yours?
Yeah.
Okay, sorry.
Thanks, Tony. When are you required to re-represent your size status? And again, these are the 3 triggering events that are currently in the FAR. So the first one is within 30 days after the approval of a novation agreement in connection, for example, with a sale of a contract from Company A to Company B. Also within 30 days after a merger or acquisition that does not require a novation, such as a stock sale. And then with respect to long-term contracts. And long-term contracts are contracts with durations of 5 years or more. And with respect to long-term contracts, there's you recertify at 2 points. One is within 60 to 120 days prior to the end of year 5, and then within 60 to 120 days prior to the option exercise date for any option after year 5. And again, it's important to note, as Tony mentioned previously, that this is not an all-inclusive list, meaning there are other triggering events that are in the SBA's rules that just have not been implemented in the FAR as of today. But again, simply because they have not made their way into the FAR doesn't mean you can ignore them. I mean, you can't. I mean, SBA's rule is the law. So you kind of need to look at, and when we get to the slide about SBA's rules and their triggering events, you'll see that all of these actually are included in SBA's rules, and SBA's rules just provide additional triggering events. So how does a contractor re-represent under the FAR? If you experience a triggering event, you are required to update and or validate that all of your reps and certs and any other data in SAM is accurate. So for example, let's say that a company previously represented itself as a small business in SAM under a $15 million size standard. They undergo an acquisition that pushes them above $15 million on a 3-year look back. Then they would need to go into SAM and update it so that any next codes that are in there currently reflect that they are other than small for next codes with a size standard of $15 million or less. And then also once you do that update or validation, you're required to notify the CO and provide them with the date of the validation with the same time frame, meaning within the 30 days or within the 60 to 120 days for long-term contracts. So if a contractor represents, after experiencing a triggering event, that it is a large business, then moving forward, the agency can no longer count the value of options exercised or orders issued, purchases made, etc., towards its small business subcontracting goals. So I guess what that really creates, in a sense, is some disincentive for the agency to exercise an option. But at the end of the day, if you're performing and you're performing well, simply because they're not, and let's assume that they're meeting their small business goals already, there's probably a strong likelihood that the option's going to get exercised regardless. And then also, agencies also have to do some things. Agencies should issue a modification within 30 days to the contract to capture this re-representation and report that to FPDS, which is the Federal Procurement Data System. And the CO should also update the size in FPDS. So as I mentioned previously, the SBA's rules, 121-404G, provides additional triggering events or additional examples of triggering events. And some of these additional examples are really just subcategories of the triggering event involving a merger or acquisition that does not require a novation. So for example, if I own 100% of company A and company B, and I go out and sell company A to a third party, I still need to recertify with respect to company B's small business contracts, even though they weren't a party to the transaction. Also, if in a stock deal, if both the seller and the buyer have been awarded small business contracts, then after the deal is closed, both the buyer, meaning the acquiring concern, and the seller, the acquired concern, need to recertify. Joint ventures also need to recertify. And that triggering event happens when, and this assumes that the joint venture has been awarded a small business contract, but if one of the small business joint venture partners to the JV is acquired or merged, then that requires or triggers a recertification requirement from the joint venture. With the reason being that joint ventures, the general rule to qualify as a small business, both parties to the JV have to be small. So the small business status of the JV partners is obviously relevant to the JV's status as the small business prime contractor.
Peter, and I would just add, as you probably know, a lot of these joint ventures that are being created these days is under the All Small Business Mentor Protege program or the AA Mentor Protege program. And in situations where the mentor is basically being acquired, to the extent that the mentor's large, and most often than not, the reason you have these mentor protege relationships is because the mentor is a large business. It really shouldn't impact the size of the joint venture, because if you maintain the mentor protege relationship in place, the fact that is a triggering event for the mentor should not then trigger that the joint venture needs to say that they're large now because they're under a mentor protege arrangement, which allows them to be treated as a small business. And we have seen these deals where oftentimes it's the mentors who are run by entrepreneurs and are companies that are constantly doing a lot of buying and selling. And if you think about, for example, a Northrop that, as an example, has multiple subsidiaries, to the extent that they're sometimes selling subsidiaries or they're buying companies, that starts triggering all kinds of recertifications given the way this rule works. But it really should not impact that mentor-protege relationship. Yes, Lisa? If there's an acquisition or a triggering event, okay, no, natural growth normally doesn't impact you unless you have one of these long-term contracts that at the 5-year mark you need to recertify. Because if that then happens, then you're not going to be able to recertify as a joint venture if it was based upon both being small. But technically, the way it should work is just the agency should exercise the option and they just can't continue taking credit. But the problem is, as we'll discuss later, there's a regulation the SBA just issued a few months ago, which indicates that you shouldn't be bidding on any work then. If you have now on a small business a long-term contract indicated that you're now large, technically you could still compete for the work, but agencies couldn't take credit. And the SBA is saying, no, you really shouldn't compete for the work because you recertified to being large, so you're not eligible to pursue any more work.
Thanks, Tony. Also, so if there's a merger or acquisition that occurs after the proposal goes in, but prior to award, the offeror is required to recertify its status to the CO prior to award. So what that means is you're not necessarily going to be kicked out of the competition, but if you are awarded the contract, the agency can't take small business credit. So again, there may be a disincentive, but if you submit a very competitive proposal and you are the best value offeror, then there's a good chance you're going to still win the contract.
And I'd like to add, this is actually a new rule that the SBA just issued. And when you really think of the procurement cycles can take sometimes, 8 months, a year. We've seen them take longer than that. During that period of time, a company may actually be engaged in an acquisition. And we've always been of the school that, before this regulation was issued, that to the extent that you don't have a contract in place with the government that requires recertification or notifying them of anything, why would you tell them, oh, we've engaged in an acquisition? But with this rule now, if you are submitting an offer and you have an offer pending, you need to, while doing any kind of negotiations that result in a deal being struck that results in some kind of a sale or a buy, you're going to have to then tell the contracting officer. And there's really no clarity regarding what is a contracting officer going to do if you actually get the award. Because if you competed for it, and you were small at the time you submitted your proposal, which, as you know, size is determined at the date you submit your initial proposal, including price. The fact that you may now be large shouldn't impact your eligibility. But what's a contracting officer supposed to do? When I was sitting there faced with the company they thought was small, was going to give them credit. And something's going to have to be decided through protest. Someone's going to feel that they got screwed out of a contract, and they're going to protest. Or someone who feels that they should have been awarded the contract because the company that was selected for award is now large.
Yeah, I guess one tip would be if you have to make that certification prior to a recertification prior to award, would be to explain exactly what Tony just said as part of that notice to the CO, meaning that eligibility is determined as of the date we submitted this proposal, and as of the date we submitted the proposal, we were small.
And I'd like to add one more thing too. What if you decide not to do it? One of the big issues, and this is why this really gets into the weeds of these rules, this is in the SBA regulation, okay? Normally you get in trouble as a government contractor when you actually tell the government something that's false. This is telling, under the SBA regulations, you should go ahead and tell the government. But what if you don't? What is the government going to do? Because you don't have a contract yet, and this is not in the FAR. That's another thing. This is a provision that's just been added in the SBA's regulations. It is a law. It's a regulation. And you should follow the regulations, but I could see contractors saying, well, I'm just not going to tell the government. I'm going to get this contract, and I'm off to the races, and who's going to know about it? And who's going to care? The procuring agency is going to get the services they want. They're going to continue getting credit, and they did not sign a contract at the time this rule was in place that forced this upon them. Again, these are the areas that we see. We're very conservative as lawyers. We're very risk adverse, which we're telling our clients, look, you should do this, you should do that, et cetera. But I can tell you that I've already spoken to people who are saying we're not going to do that. And that's but how do you then, if you're competing with a company that has that attitude, you may want to protest. If you think that there's something wrong here that you've heard, because a lot of companies, they engage in acquisitions and they put press releases out and they start telling people they're very happy about what they're doing without realizing that they're now letting their competitors know things that could trigger protests.
Thanks, Tony. And then lastly, and Tony will get into this a little later, you're also required to recertify in connection with a task order if, as part of that task order solicitation, the CO explicitly requires the offeror to recertify. So real quickly, what is the effect under the SBA's regulations in terms of recertification? I mean, these are the things that we know for certain. Similar to the FAR, if you re-represent yourself as a large business, the agency can no longer count the value of the options exercised, modifications made, and task orders issued towards its small business contracting goals. And those for MACs, certain MACs, recertification, meaning having to recertify as a large business, or let's just say you're no longer an SDVOSB, can lead to what's called off-ramping. And some of these larger MAC contracts have these unique off-ramp provisions that basically give the discretion, or agency the discretion, to terminate the contract for convenience. If there's an event like a merger or acquisition as a result of that event, you're no longer small, you're no longer an SDVOSB. I know, for example, VETS 2 has an offering provision that reads just that way. And then again, if a CO explicitly requires recertification in connection with a task order and someone files a size protest, size is determined as of the date that the offeror submitted the proposal for the task order solicitation, meaning size doesn't relate back to the date that they got on the vehicle.
So how do you know whether you've been asked to recertify on a task order? And this is an issue that we deal with regularly because of the way that a lot of contracting officers, without really knowing the impact of what they're asking for, how the government contracting community may perceive it. And it's very clear that a request for recertification has to be, quote, explicit, and also has to include the size standards that's being applied for that particular task order. And of course, these are obviously issues involving these multiple award contracts, which so many companies are receiving these days, and the government is just awarding a lot more multiple award contracts. So it essentially, brings the competition to the task order level. So now you've received the contract that you thought you were eligible for with a number of other companies, but now they start asking for verification of size. And this is something we see oftentimes, that a contracting officer said, we want you to verify your size in SAM. Well, does that mean, yes, what we have on SAM is accurate? And that arguably is all you need to do in that situation, because they're not asking you to recertify your size. They're just asking you to verify whether your registrations on SAM are accurate. And they were when you submitted that verification on SAM during your yearly update, you should be able to say yes, even though you now may be large, because they haven't asked you to recertify. So it's critical that these representations are, by the contracting officer, are clear to you. There's an area, though, of gray because of decisions that have been made by the SBA's Office of Hearings and Appeals and the GAO in terms of what could be considered explicit. They don't need to use the word actually certify or recertify. And of course, this is a problem because now you get into this area where what happens if they ask you to verify? Now, as far as we're concerned, we let our clients feel comfortable because we'll provide them with an opinion that we don't think a verification alone is a recertification request. And this is something that you should probably do. If you're not sure, seek the advice of counsel before you do a verification or certification, because that will provide you protection if, for some reason, a case comes down the road that indicates it's different. Because you have a good faith belief based upon advice of counsel as to whether you have been asked to recertify or not. And we, like I said, we're very risk adverse, so we would be careful in terms of what we would tell you. We wouldn't push the envelope, but if we think that the contracting officer is just being sloppy in the way he's asking you to basically indicate that all the stuff that you've got on STAM is accurate, current, accurate, and complete, I think that's all you need to do. You don't need to recertify. You should note that, yes, sir. Not really. It's not. It's not. The only times we've seen that we believe that they're doing this is because they really are looking for certain companies to be the ones that are competing for the work, and they know that something has happened with a company, or they've heard that there's a lot of information out on the street regarding companies that are become too large. A lot of these companies are meeting with the contracting officers regularly or contracting shop, and they're talking about how this other company seems to have received all these contract awards. And if for some reason that company is not really doing work the way the agency likes, that's a good way of squeezing them out of the competition. I'll tell you, though, a lot of times, I'm not sure why a contracting officer would want to do that if they have a group of companies, some of which may now be large, but are doing excellent work for them. They're able to still get the credit, and they're getting companies that are now basically large businesses doing the work very, very well. Why give themselves a headache of now bringing in a small business that may not perform as well as a company that has been successful enough to grow and become large? So we always do question, why would a contracting officer ask for a recertification of size? It's really going to limit their pool of competitors overall. But it does happen. It does happen, and our clients oftentimes tell us that this is happening because an agency really doesn't want them to be in the competition, and that they're looking for somebody else. And you know how the game is played. I mean, unfortunately, there are favorites. Is there anything else there, Peter, that I need to address? I think
Yeah, I think you got it.
I hit it all. Okay, cool. Why don't we go to the next one then? What is, okay, what is the effect under the recertification under the SBA's regulations? Issues that are less clear, but are, what contracts must be recertified? Keep in mind, within 30 days of an approved contract novation, a contractor must certify its business size to the procuring agency with regard to that contract. So one of the things that we do see a lot of clients do is they don't really want to engage in a wholesale sale of the company. They just want to go ahead and novate contracts or sell certain assets. And that then does limit the kind of certification you need to do, because the certification now is just tied to that specific contract and not to all the other contracts the company has. It only impacts size with regard to that particular contract. And that certification is then has to be done by the company acquiring the contract. And it doesn't really impact all their other contracts that they have.
Yeah, and the one thing I'll add, the regulations aren't, they don't, clearly state that, but the way that it reads, it references the contract, the novated contract, the procuring agency. So, our position in terms of the language of the regulation is that it is referring specifically to that one contract, and not any other small business contracts that they may have.
And then, with the next slide.
Yeah.
With regard to when you don't have a novation, this is now when you're dealing with a merger, sale, or acquisition, and where contract novation is not required, okay? Because the rules for a long time, the SBA regulation is very clear that whenever you were novating contracts, you had to recertify. And the SBA has been issuing every couple of years a new recertification rule that tightens up when it is that they're going to require recert. And essentially, it indicates, and keep in mind that with regard to novation, the moment you do the novation with another company, is it really viewed as a final novation until the government has signed the novation? So one of the things to be thinking about is the timing of when it is you want to do one of these deals. But with regard to, for example, an acquisition or sale, you have to basically recertify on all your contracts within 30 days of that contract being final. And I will tell you that with some contracts being executed during an acquisition, which are not really finalized that very moment because there may be certain contingencies that are in effect, we do know situations where companies take the position that I'm not going to recertify yet, even though I've signed a sale agreement, because there are certain post-closing contingencies that need to be met to make the deal final. And that is gaming the system, but that is an argument that can be made, that to the extent that the rules say it's only when one of these deals is final. The way they've created these, the rules though, the way they've tried to tighten up this rule with the SBA is that, they're requiring these recertifications to be made both by the seller and the buyer, and by all the affiliated entities that they have. So it's amazing how, it really has such a wide-ranging effect. If you are a small business owner pursuing government contracts, you may have another little company over on the side that perhaps just holds real estate, and you've decided to sell that entity with the real estate. There's a lot of business owners, that's the way they hold real estate. That would trigger recertification on your contracts. And so if you've had natural growth, but you're now spinning off a little subsidiary, that can then trigger recertification. Or if you're buying another company, a little company that you realize, I need these potential IT tools that another company has, or whatever it is. So it really has a very, very, we believe, detrimental effect on the M&A market for small businesses, because you've got to be careful how not only you're operating, but affiliated entities of yours. And you think, well, they're affiliated entities of mine, I know them, I control them. But sometimes you have multiple other individuals that are running your companies. And you may think those are not small businesses, but a lot of small business owners have interest in many different companies.
Next. Did you get it?
Yeah. And what is the effective recertification under SBA's regulations? One of the the analytic case. Okay, this is a decision that was very, very interesting that came out early this year, which we were involved with, where the SBA basically, a company was there was this company that was owned by a service disabled veteran, and it was sold to a larger business, and the company continued bidding on contracts as a service-disabled veteran-owned small business. And the issue came out as to whether they were still eligible for it or not. And the SBA's Office of Hearings and Appeal held that because this contract that this company had, under the regulations, should have been treated as a contract awarded to a service-disabled veteran-owned small business for the life of the contract, that company could continue pursuing the work as an SDVOSB, even though it was no longer an SDVOSB, because that's what the regulations said, okay? When we saw this, we were actually really surprised, because it has a huge impact if you read the regulations that way also on long-term contracts. Because if on a long-term contract, you certify at the 5th year mark that you're large, and you continue bidding on work as a small business, even though you've told the government you're large, you know, what about all the other small businesses that certified to being small? So we had always been telling our clients, look, once you've indicated you're large on one of these long-term contracts, I mean, you really shouldn't continue bidding on work because you're telling them you're large. OHA came up with this decision, which was very perplexing in terms of the way they were reading the regulations. And the Office of Hearings and Appeal is sort of the final arbiter on these small business issues, unless you go to the courts, and rarely do the courts really overturn OHA. The bottom line is, within a month or two of that decision coming out, OHA issued what's called a technical amendment, where they added the term "however" at the end of this clause regarding recertification, indicating that if you engage in any of these triggering events that require recertification, no longer can those contracts be treated for the life of the contract as either small or being awarded under one of these other programs. So they basically expressed what SBA probably originally intended, but what the regulations didn't say. And so what's ended up happening is they had to not only change the rule in the small business regulations, but also they had to go back to all the other regulations for all the other programs. Because several years ago, what the SBA did was, not only did they clarify when you need to recertify size for size purposes, but also with regard to these other programs. If you were still a service-disabled veteran-owned small business, a WOSB. Because if you have a WSB that changes hands, and it's not impacting their size, you could have a situation where you have a man running a company that's got contracts that were originally awarded to women, a women-owned small business. So what they did was they required this recertification that not only impacts size, but also status. And what this holding by OHA did was really made it really the Wild West, that you could essentially continue selling these companies, being large and competing for work. And SBA issued this technical amendment. But the way they issued this technical amendment, you know, they never asked for comments from the public. They called it a technical amendment, which isn't really a technical amendment. When you look at technical amendments to regulations, it's because they need to fix typographical errors or cross-references to other regulations that are just not accurate. They don't really engage in substantive changes. But this really was a substantive change, but they sort of just threw it in there, and the small business community now has to live with it. And frankly, I'm not sure if there's anything folks can do other than go to Congress to try to change some of these rules, because the SBA feels very strongly about these recertification rules, particularly as they impact their data collection. Because that's what they're saying this is all about. They need to make sure they have the right data on who the companies are. I have to tell you that because of the way the SBA did this technical amendment, it's not clear at all. They didn't explain it. And I think there are arguments to be made that this decision still is the law of the land, because the SBA did not clarify what they were trying to do and just added these words that we know from people we speak to at the SBA what they were trying to do. But most people that haven't spoken to people at the SBA who tell you what they're trying to do wouldn't understand what that really means when they did that. Yes?
Would you mind summarizing what that means?
What this means essentially is that if you look at what the SBA is trying to do and with their regulations, is they want to make sure that if you engage in any triggering event that results in your status changing, you should not be eligible to bid on that work anymore. Even though the way the rules always been read in the past is the agencies should not be able to take credit, but you should continue being able to perform the contract, so you put so much time and money into pursuing these contracts in the first place. And the rule was that you are of that status for the life of the contract. But the SBA is now basically saying, you really aren't eligible anymore. And that's the way they've done it through this technical amendment. It does really change the way that companies can compete.
So certain agencies that don't have small
Well, we do represent a significant number of clients that are regularly doing novations, and really agencies can't, they can deny, say no to a novation agreement because they have to sign off on it. But I'd say 90%, 95% of all novations are approved by the government. The only problem you may have is how happy they're going to be with all the paperwork it creates, and whether it's going to impact their ability to get the small business credit. And I think for agencies that are doing very well meeting their goals, they're not going to care. It's the agencies that are not meeting their goals that may realize that you've only, made it more difficult for them. So they may try to look for another vehicle.
So you're saying, say my company won a MACOM, small businesses have MACOM, or 8A is have MACOM. There's a triggering event, we're no longer, so we recertify, and 5-year contract, $20 million ceiling, but for those follow-on task orders that come out, this language says that I'm not eligible to compete for those task orders because my status has changed.
Essentially, yes.
That's not good.
Yeah, it's not good. Now, well, but there's also the issue as to whether you're being asked to recertify, okay? Because if you're not asked to recertify, then you should be okay. Because all you're doing is just changing your status on the books. You go to SAM, you go boom, okay, now we're large. You could continue competing for the work. The issue is going to be when do they ask you to recertify?
So what does the rule mean to you? The rule became effective on May 28th of this year. It should not arguably apply to solicitations issued after that date, or only apply to solicitations issued after that date. And it could also be argued that if you have a pre-existing MAC, meaning something that was awarded prior to May 25th, the effective date, that it shouldn't apply to task orders against that MAC, even if they are issued after May 25th. But as Tony noted, if it does apply, then you have to recertify it as being other than small, then you can no longer bid on those small business task orders. And from an M&A standpoint, I mean, the implications really could be huge. I mean, when large businesses decide to purchase a small business with a backlog of MAC contracts, they typically do so with the understanding that they are going to be able to continue bidding on small business task orders after the deal is closed. And if they can't, the value of that potential target is diminished. And I think in terms of task order recertification requests, there is some confusion. There is confusion as to when it does and does not apply, and unfortunately, that confusion could lead COs to increase the number of recertifications that they're requesting in connection with a particular task order, which it would not be a good thing, because at the end of the day, the value of a MAC to a small business contractor would be lower, simply because even in that situation, companies who haven't undergone a triggering event but have simply grown organically would not be able to bid on those task orders. So protests with respect to long-term contracts. So if you have a long-term contract, which is again a contract with a duration of greater than 5 years, you can only be protested at 3 times. First, at time of award. Second, at time the option is exercised. And then third, if the CO explicitly requests recertification in connection with a task order. And the protest risk, because of that, is fairly low. And there was a recent OHA case where a competitor tried to challenge the size of a company on a long-term contract, alleging that the company was not small at the time the option was exercised. But they filed that protest 4 months after the option was exercised. And they tried to make the argument that, you know, they only had notice that the company's option had been exercised at the time that they received, you know, the most recent task order after that option was exercised. But keep in mind, I mean, some of that, when your option is exercised, I mean, that's information that is generally not, you know, made publicly available. And they tried to take that position, but OHA came back and said that you had enough information, meaning you knew when this contract was awarded, and there was some other information that OHA pointed to say that you had enough reason to know that the option was exercised on a particular date, and because you didn't file your size protest within 5 business days of that date, the protest was untimely. And just keep in mind that the SBA, they have the authority to file a size protest at any time. So if in that situation, SBA on its own decided to either take up the protest or file its own protest, then that protest in that case would have been timely. So these are just some quick certification mistakes that your competitors may be making when they recertify, and they may be not counting or neglecting certain revenues, meaning revenues from affiliates. And I was talking to someone yesterday who wanted to start a second company because his first company was about to hit the threshold for being a small business, and we had to explain to him that, you can do that, but if you own 100% of this company and now you're going to own 100% of your second company, you're going to be affiliated. And if you're affiliated, that means that the revenues for size purposes are combined, which can obviously push you above the size standard. And, if you don't know the affiliation rules, then, you may not be taking into account revenues of your affiliates when you're making a size certification. Revenues from a novated contract. So if you are, let's say you are sold a contract, and it's not just the contract, it's all of the hard assets, meaning the equipment, the employees that are tied to that contract, and the CO subsequently approves the novation of that contract to you, meaning you are now the successor in interest to that contract, then arguably all of the revenues from that contract should come off of the seller's books and come onto yours, even though they may not show up on your tax returns. And if you're not thinking about that and you're just looking at your tax returns, you may not be properly accounting for all of the revenues for your 3-year look back.
I'd like to add that has to be structured very, very carefully. Keep in mind, first of all, it's illegal to sell contracts. So a lot of clients come to us and they say, we want to sell this contract, et cetera, and we sort of try to get them to start articulating it differently, because it is illegal to sell government contracts, but you can sell assets and liabilities associated with a contract. And if you are then structuring the deal as an asset purchase that involves the contracts, because the government will approve a novation of contracts if the reason the contracts has to go from company A to company B is that this company has decided they're going to sell all these assets, and in order for that work to be done under that contract, you got to sell those assets. And that takes sometimes, very creative drafting, because some of these contracts just involve people. There's not much computers, it's very little assets, but we work with the clients to come up with the assets that need to be sold. And in order to be able to pull the revenues out the way Peter said, you really need to have created a division. So you want to go ahead, before you go ahead and think about selling a contract or contracts, how it is that you place them in a division that now have separate books and records of how those revenues have been accounted for. Because I can tell you that if you do one of these transactions where you're selling a significant number of assets from your company, which include contract revenues because of the contracts that are also flowing through, you can pull the money out. but you've got to be able to show that there has been a way that your company has been keeping track of these revenues separate from your other revenues. Because if they haven't been kept separate, then you're not going to be able to make the argument that the money should be pulled out, because it's been all intermingled with everything else you're doing. So I've worked with a number of clients over the last couple of years who have come to me early enough to explain to me that, oh, we're going to get really big. What's going to happen? I said, well, let's restructure your company. Let's figure out how we restructure internally so you can spin off some of your least profitable contracts, but that are generating tremendous revenues. And you really do need to plan that ahead.
And then with respect to joint ventures, if you're a partner to a joint venture, you have to account in your revenues and take into account your proportionate share of your JV revenues. So again, if you're basing, and sometimes those revenues, especially if you have formed a JV as a separate legal entity, they're not necessarily going to show up on your company's tax returns. So if you're just looking at your tax returns and using that information to make the certification, but you're not accounting for your proportionate share of joint venture revenue, then again, I mean, that's another mistake. And then just some other issues. I mean, there are people that just don't understand how size is calculated, meaning that it's if looking at a tax return, it's usually line 2 plus line 6, which is costs, total income plus cost of goods sold. And there are some companies that don't realize that revenue is not your revenue for the most recently completed fiscal year. It's on a 3-year look back. Outdated company websites. We've seen companies who may have done an acquisition where they divested themselves of a company that they either owned or were affiliated with, but they didn't go through the process of updating their website to make sure that company was no longer there. And they make that certification at that time, and someone wants to they get the award, and someone wants to file a protest, and they're just clearly pointing to information on the website that's just outdated. I mean, at the end of the day, they may keep the award because they no longer are affiliated with that company. But simply having to go through a size determination, even if you win, is an administrative headache. And then poorly drafted agreements, meaning teaming agreements and joint venture agreements. So, for example, if you have a teaming agreement that's vague and that does not assign discrete contract functions to each parties, you could be potentially found affiliated under the ostensible subcontractor rule. And then similar with JV agreements, let's say between a small business protege and its large business mentor, if that JV agreement doesn't contain every required provision in the SBA's regulations and doesn't speak to the performance of work requirements, meaning how the JV is going to meet its performance of work requirement, and how within the context of the JV itself, how the individual partners to the JV are going to perform their respective percentages, then you're at risk and likely to lose the award because you'll be found affiliated. So certification. So as a small business subcontractor to a large business, what should you be expecting to see in your subcontract in terms of recertification requirements? And it may be none, because as Tony mentioned before, there is no requirement that a large business flow down certification requirements to its small business subcontractors. That said, some do. And one of the reasons is that the presumed loss rule, which we'll get to in a few seconds, applies to subcontracts. And what that means at a high level is that if a large business is taking credit for subcontracting to a small business who turns out to be other than small, then they're at risk of potential liability. You can be protected from liability if you can demonstrate that you relied on any representation made by that sub as to their small business status in good faith. And that's what the rule says, but it doesn't really say anything about what is and what's not good faith, so it's unclear. But if a large business prime gets a written representation from its small business subcontractor, who later turns out to be a large business, then arguably that would meet the good faith test. So lastly, the impact of making a false certification, and what are the penalties? Well, there's penalties under the False Claims Act, roughly no less than $11,000 in change per violation, and no more than roughly $22,000 per violation, plus treble damages, meaning 3 times the amount that the government sustains. And keep in mind that per violation language is really important, because every time that you're submitting an invoice to the government and it's under a misrepresentation of size, that could be considered a violation. So the presumed loss rule, this rule basically says if a contractor willfully seeks and receives a small business set-aside contract based on a misrepresentation of size, there is a presumed loss to the government that is equal to the total amount of the contract funds expended, which means that you could be potentially liable for the entire contract amount. And there are also civil penalties, criminal penalties, imprisonment and fines, and you could be suspended and debarred. But with respect to this, the penalty the presumed loss penalty, meaning the total amount expended on the contract, that only applies if the company actually received the award. And with that, are there any questions?
If a company anticipates that they are going to go over the threshold and move from small business to large business, and I think in the consulting field it's 15 million a year, so they know they're up against that, they know that the 2018 tax results are going to push them over. What's to keep them from recertifying the day before their taxes are submitted, March 30th of next year, and that would at least allow them to go forward for another year as a small business? Is that, am I missing something here, or is that actually considered kosher?
So you're talking about just growing organically?
Yes, growing organically and getting beyond the threshold to consider small business. You know that this year is going to be a great year, and once you have that on the books, you're no longer a small business. Can you recertify?
Well, you wouldn't be recertifying because you're growing organically, but I mean, we have seen situations where, let's say that, like, take your example, for example. I know. let's say that there's a solicitation that, the proposal due date is January 1st, 2019, and they know that after, the end of 2018, they're going to be a large business. We have seen companies submit the bid prior to January 1st, meaning you submit it at the time when the 3-year look back is not 18, 17, and 16, it's 17, 16, and 15.
But the issue there is, you really are looking at these solicitations and we see this actually a lot in January, where clients realize they're going to be large, but they don't have their income tax returns. But that's really not determinative, because even though the SBA does determine size by looking at your income tax returns, if you were to be protested or if you were to be investigated, by then, given the process, you will have those income tax returns. And the fact that you made this misrepresentation get you in trouble. So unless you really don't have any clue to how small you are, you have to be very careful. Now, we've had situations where clients, normally what happens is that proposals are due on January 15th or January 16th, and they're submitting their proposals on December 31st. That way they can do this. And there are agencies that will take those proposals and consider them, and I think they realize, why are you submitting this proposal so early? And these companies, assuming there's discussions with the agencies, will say, because we're still small, and they're fine with that. Okay, as long as you are accurately certifying at the point in time, okay? But the truth of the matter is, a lot of these, what if there's an amendment to the solicitation? And now you need to resubmit your proposal. Now you are in January. And where we do have a lot of clients that tell us, so Tony, but I don't have my income tax returns. I don't have and a lot of companies don't have their income tax returns done until October, because you can get the extensions, et cetera. But you can do the numbers on QuickBooks, et cetera. You can get your financials. You can talk to your accountant, and you have a pretty good idea. The only time that I think you can sort of get away with that is if really the numbers are so close that you really have no idea, and you in good faith make the representation, and you can show that the data you have as of December 31st made you believe you were small.
So if you were to go back in on March 28th and say, okay, we're still going to use 17, 16, 15, and using those numbers, we're still small business. Come June, several months later, you really, if you were to try to go after small business contract at that point, they would say, no, you can't do it, because now you do have 2018 results that show you're no longer small business, we're not going to allow you to be small business.
Well, they wouldn't know this. I mean, obviously, this is something that you have to certify yourself. They're going to rely upon.
That's my point. If we were recertified on March 30th using the three previous years, and 2018 is not ready yet, in my mind, we're still a small business. In June, we'd still be a small business. In October, we'd still be a small business. It wouldn't be until 2019's, until that 12 months has passed, and then you have to recertify again, that you'd have to say, yes, we're no longer a small business.
If, in your situation, if you honestly believe that you just don't have the information, and there's no records actually, I mean, their financial statements, et cetera, actually don't clearly show what your revenues are, you go ahead and continue bidding on contracts as small business. Now, July comes along, August, you win these contracts. All these things, bids you submitted, somebody protests. If they protest and you have your income tax returns done, you have to submit them to the SBA. If your income tax returns are not done, but you have financial statements, because the SBA will ask for financial statements, and those you can obtain, then they will do the determination, and if they see that you're other than small, they will disqualify you from the competition. So that would be, quote, a worst case scenario. I mean, an even worse case scenario would be if not only do you get disqualified from the competition, but the SBA refers this to the IG because they said, what is this company doing certifying to being small when their financials still clearly show that they had all these extra revenues? That rarely happens, but it could happen. It could happen. Yes, sir?
Two questions. First question is, I have a mentor proposal certified by SBA as a small business with one of the companies. That company is also an 8A contractor. So can I use that mentor proposal for doing business as an 8A as well as small business?
Yeah. Is your mentor protege agreement through the all small mentor protege program? So if you want to apply to the mentor protege, let's just say an 8A wants to apply to the mentor protege program, they can either do it through the all small or they can go the 8A route. And but at the end of the day, regardless of which route you go, and you went all small, just because you went all small doesn't preclude you from using that mentor protege agreement and joint ventures formed under that agreement to go after 8A work. And
Precludes or doesn't preclude?
does not preclude.
It means I can go after the 8A projects also.
Yeah, and I mean, we're seeing a lot of companies do just that, meaning why go through the process of applying to the SBA's 8A mentor protege program when that process usually can take several months, and the all small program I think right now is averaging about a month to get an application approved. And just so you know, the SBA is considering just consolidating the two programs, meaning there's just going to be the all small program, and the 8A program, meaning the mentor protege program, is going to go away.
We are not sure right now. If I have an 8A opportunity, let's say my protege has an 8A opportunity, and I'm doing this as a joint venture with them as my company and that, but I'm a large business. So is that okay?
No, well, you have if you have an approved SBA mentor-protege relationship, and you're large, then you can joint venture with your small business protege for any contract that they would otherwise qualify for, meaning your status as a large business is irrelevant.
But I cannot use that mentor program which I have right now in place on the SBA. I'm from SBA as a small business mentor program. I cannot use that.
No, you can use it for any contract. So if your protege is 8A, you can use your mentor-protege agreement under the All Small program and take the exemption from affiliation that you get under that program, like the 8A program, and you can joint venture as a small business. It doesn't matter that you went the All Small route as opposed to the 8A mentor-protege.
And then another question I have quickly, at the size protest, the company is, large company is owned by a trust, family trust. How does that work? And that trust owns other businesses.
That, yeah, I've actually, the SBA has dealt with these situations, but if you have a trust that owns companies and there are trustees that are controlling these different companies, they can all be deemed affiliated. So, yes, they definitely can be affiliated. Any other questions, sir?
So I have a very small business. I wish there was a designation for that. I'm serving as a sub-consultant on several indefinite delivery contracts. If I sold my business to a large business, is it my responsibility to recertify, or is the large business then responsible for my recertification?
The recertification has to be done 30 days after it's final. So if they've bought your company, I think they now have all the obligations to do the recertification. They should. Yeah. Yeah. And keep in mind, by the way, with regard to these recertification rules, something that we can really get into the weeds on this, and I really appreciate you guys having patience to sit through this because it's so, arcane, but it's important. If these rules are actually designed to be triggered when one company buys another company. So if you have a small business that's now become large, but you sell it to another individual, there's no recertification requirement. Because the rules talk about concerns, acquisitions by concerns, not by individuals. And of course, this is, again, another loophole the SBA may eventually close because, we figured out the way they've written things that you can just structure the deal differently. Most deals are not being done that way, though, obviously. Most of these government contractors are being acquired by other government contractors. And obviously, there is an issue if you're talking about a woman-owned small business being now acquired by a man, that is going to require some certification because of status. But it wouldn't with regard to size.
I guess to extend that just a little bit, does it affect, in other words, I was part of the small business subcontracting plan of a large business that got this indefinite delivery contract. So when I'm purchased by a large business, now I'm no longer small. How do I have to report that to the large business that we were part of their subcontracting plan?
Well, as Peter said earlier, most federal government prime contractors are not flowing down the recertification requirements. I mean, I don't see why they would do that, because as long as you're in good faith, believing that your subcontractor is telling the truth, that's all you got to do. And why would you ask them to continue doing that? Normally what matters is when you submit that bid with your initial proposal to the subcontractor, to the prime contractor. And so therefore the government makes things difficult for itself because it's got other issues it's got to deal with, which is gathering the data. For a prime contractor, it just has to in good faith believe when they awarded that original contract. Now, I could see a prime contractor wanting to do that if their goal is to ultimately squeeze out the subcontractor, right? Because you know how that works. And they may determine, you know what, if they've got reason to believe that it's a subcontractor, you don't want your subcontractors to be assigning their contracts, to be selling. You want to continue working with the people you gave the subcontract to. So there are certain provisions you put in these agreements that give you exit from the arrangement to keep more work for yourself or bring somebody else in. Now, obviously, you're likely to want to bring in somebody else that's small, because if you're not meeting your subcontracting goals, and that is going to impact your past performance, which I have seen happen. It's not often, but I have seen prime contractors get dinged when being evaluated on contracts because they didn't meet their subcontracting plan requirements. And I will say that, you know, you always hear about the horror stories, but most people are trying to do the right thing and follow the rules. Large businesses and small businesses. There's just a very few people who, you know, either don't know any better or just, you know, outright crooks. But that's not really the norm in our experience. I mean, people are coming to us because they want to do things right. So what you need to do is look at your contract with the prime, see what it requires you to do. Anything else? Oh,
Tony, let me ask you, going back to something you said earlier about if you had an indefinite quantity contract, a current contract, and in the middle of that contract you became a larger business. You talked about updating the SAM, which I understand that, but then you talked about the recertification is which would get you potentially into a situation where you no longer qualify for, let's say, a task order. But you kind of talked about only if the contracting officer was asking you to recertify as opposed to having to automatically recertify. So I guess I'd have to think back to, as each task order comes out, aren't we already asked to almost recertify or by
no. This is why it gets confusing. Keep in mind that organic growth, where you just are getting larger and larger and larger, so, you know, you get a contract, first year you get the contract, you're small. Year 3, you've won tons of contract, now you're large. You go to SAM, every year you have to update your SAM, and now you're indicating you're large, right? Now task orders start coming issued on these other contracts that you originally won, okay? You should still be able to compete for those task orders if the contracting officer doesn't ask you to recertify. There's no reason for a contracting officer to ask you to recertify during those first 5 years, okay? The only reason you would have to recertify is if there's another triggering event. Okay, just growing doesn't trigger anything, except at the 5-year mark, because there's a contract that says you got to tell me at the 5-year mark whether you're large or small. So that's really what it comes down to. But imagine if in year 3 of this contract, you've had organic growth, but now you engage in an acquisition of another small business, a real small business, but you've had organic growth. That acquisition, that small business, is going to trigger a recertification on all your contracts. You're still eligible to compete for those contracts, okay? The agency can no longer continue taking small business credits. As for them, it's going to be like, you know, why do we need you? We're trying to get small business credit. We got all these other companies. And so they may then start asking for recertification of everybody.
So you think that the new technical memo, or whatever you call it, doesn't preclude them from at least allowing those contracts to be had, just them not getting credit for it?
But not, right. But I think that you have to be very careful once you're, a transaction that impacts, for example, going to becoming, if you were an SDVO, and now you're no longer an SDVO, and they're issuing task orders even that don't require recertification, I would not be going after those contracts, because that's what the SBA is basically saying from these rules. Would you agree,
Yeah.
Peter?
Yeah.
Anyway, thank you guys very much. If you have any other questions, we're at a booth below for at least maybe another hour, because I don't know when they're closing everything up. But, you know, you can always email us. You can always call our office. Where, you know, it's a privilege to be able to speak at events like this and to represent clients like the ones that we have. And that, you know, hopefully if you guys need someone to help you, we can do it for you. And if we can't, we'll let you know.
Thank you.